Mr. President, the original legislative intent of the Medical Registration Ordinance was, I quote, to consolidate and amend the law by making more comprehensive provisions regulating the registration of practitioners in medicine and surgery, end of quote. One of the objectives are to maintain the standards of practice in medicine and surgery through the complaint system by making the petitioners accountable for their professional performance. However, the complaint system of the Medical Council is notorious, inadequate, and efficient. It is time-consuming and ineffective, as seen in the case of Law Yu Wai Ray and Medical Council of Hong Kong, Chairman and the Deputy Chairman of the Preliminary Investigation Committee of the Medical Council, and Dr. Chen Yi-Seng Alvin, where the complaint took 2 years to get past the first screening stage and another 2 to be rejected by the PIC. Another example would be Chang Song-tak Peter, a very famous singer. His case, it took him 9 years to decide that the doctor in the case was guilty of professional misconduct. Cases like this trigger the present discussion, that is, the Medical Registration Amendment Bill 2016. Mr. President, for me to continue my discussion and this debate, I believe I have to provide some background information on the current system of complaint. The current system is a 3-stage system, and the first stage involves a screening to be done by chairman or the deputy chairman single-handedly, who will consider whether the case is groundless or flawless. If so, he has the authority to dismiss the case. This is supposed to be a prompt appraisal of a complaint to remove an obvious case that is groundless and should not proceed further. However, as was seen in Law Yu Wai and Medical Council of Hong Kong, the first stage can take up to 2 long years. Mr. President, we are talking about some very helpless victims and their families, and it took them 2 years to go through the first stage. At this stage, screeners are entitled to consider not only the specific complaint and the supporting materials as a whole, which they should do fairly and reasonably, but also to consider where there is any other matter or allegation that may appear to raise a question about the medical petitioner's professional conduct. The underlying rationale for the screening process under the scheme was explained clearly in the case of Dr. Leung Kam Chong Kenneth and Medical Council of Hong Kong, where it was stated clearly that it was to ensure that medical petitioners are not vexed with complaints which might turn out after inquiry to be groundless. And since the role of the first stage screeners is a very narrow one, which requires them to filter out complaints which they are satisfied should not proceed further, he must be satisfied of a negative in that the normal course of the complaint proceeding to the PIC should not be followed. At this stage, Mr. President, if I may pause here and echo the honourable member of the legal constituency, Mr. Kwok, what he said earlier in his speech, we see a lot of problems happening at this very first stage. Number one, the chair or the deputy chair, he has to single-handedly handle all these cases. And I will further elaborate on this particular point in the later part of my speech. Now, we move on to the second stage. If the complaint is not dismissed after the first check, then we come to the second stage. There would be a check by the PIC, and there would be conducted as to whether or not to refer the case for inquiry and determination by the council for inquiry. This is a very detailed consideration of the complaint, and where the medical petitioner can submit information in response. The purpose of this stage is to seek the view of the lay member of the PIC so that a complaint is also looked at from a layperson's point of view. If the PIC is eventually satisfied that there is a prima facie case, they will refer the case to the council for the council's final examination. Now, Mr. President, we spot 4 very major issues of why this system is currently so ineffective and unsatisfactory, not only to all stakeholders. We are talking about the patients, victims' family, we're talking about petitioners, and of course, the public in general. First, as I mentioned earlier, the chairman and deputy chairman, they are both full-time practicing doctors. And as we know, they have a very limited time to spend on their duties with the medical council. And this is the main reason for the delay in inquiries, because they simply do not have the time to do their work. Of course, as the honorable member of the legal constituencies mentioned earlier, some of these chairmen and deputy chairmen, they might overlook the case. They might spend more time, more than necessary of time on these issues. Their job is supposed to look at whether there's a prima facie case, whether it is groundless, and move on. Some of them would have abused their powers. So, that is to say, the bill could have solved this problem if we make the chairman or deputy chairman, that position or that office, a full-time position, or at least allowing the chairman or the deputy to delegate their responsibility in first screening to a professional. That is, there could be a lawyer, there could be any other person who is able to take up the job in an efficient manner. And by what I mean efficient manner, that is, Mr. President, justice. And we all understand justice delay is justice denied. Secondly, the chairman and deputy chairman, as well as PIC, they often sit to do more than they have to do. And I refer to what I said earlier. Their job is to examine whether the case is groundless. But very often, as seen in many, many cases, some of them were reported in court, that they end up actually doing the examination, whether there's a bridge or whether the applicant has a reasonable chance of winning, and which takes up more work, time, and effort. It is not for the first stage screeners to arrogate to themselves the role of the PIC and decide whether the complaint should be referred to the council for inquiry. Still less to arrogate to themselves the role of the PIC and weigh up conflicting evidence or judge the prospect of success. In this aspect, the bill, and we are talking about even after with the amendment, would not help to solve the situation because the chairman or deputy chairman will still have to do the work. What may help solving the problem is to employ a full-time chairman, as I mentioned earlier, and to provide more training on what they should be doing. Another source of delay is when medical expert opinion has to be sought from outside counsel. That is, they have to seek a lot of medical expert opinions from other practitioners if allegations involve specialist knowledge, and this takes up time. And usually it could take up years and years of expert opinions because they have to identify an appropriate expert as a first step. Then they have to speak to the expert. Then the expert would take time to find out the problem, identify the issues, and write up their reports, which could take up another long time. And that expert who would be willing to provide assistance to the council for this particular purpose. Also, Mr. President, lay members of the council may take longer time to study and consider allegations involving medical evidence. And that makes perfect sense. Even in this chamber, we have only a few doctors. And how would us expect lay members of this medical council would have the expertise equal to their counterparts in the medical council to have the expertise to digest and understand all these materials within a short period of time? So, I was going to suggest, Mr. President, that when it comes to the PIC stage, when all these lay members, it takes them a long time to study the materials before the real issues have yet to be crystallized. We have all these delays. And, as I said, as I suggest to the Secretary, this bill with the amendment, even eventually the Council pass it, even if it becomes law, it will not help what is happening right now. It will not bring justice to those victims' family, because we have all these problems right now. The problem with this bill, as I mentioned, is it failed to address all 4 of the above-mentioned questions that need answering urgently. However, it is a bill that proposes some form of reform which is urgently needed to maintain a high standard in the practice of medicine and surgery, and to reduce chances for cases such as Law Yiu Wai and Zheng Shong Tak to happen again. The court has more than once, Mr. President, criticized the current system. And no doubt, we understand and we give credit to the Secretary and his colleagues. They are trying to bring reform. But is this adequate? Is this something we need? Is this reform something that can really solve the problem that is currently happening? I beg to differ. Reform should have taken place a long time ago. The General Medical Council of the UK began their process to reform decades ago, and they published 6 reports. Their final reports came in 2005, namely the Shipman Inquiry. And I shall refer to this Shipman Inquiry in my submissions, in my speeches later. And that Shipman Inquiry means that Hong Kong is almost 11 years behind. We should not have to wait for further misfortune to happen for us to really take a crack at what is now the defect of our system. But, Mr. President, we see that the Medical Council doesn't only need a small reform like our bill, like this amendment bill. We need a big reform. We need something groundbreaking. We need something that can really change the fundamental system of this Medical Council. As a professional myself, I fully understand their fears. I fully understand how painful it could be to a professional if he or she is alleged of professional misconduct. I can fully understand that. And that is why, precisely the point, why this small step of reform is not enough, is not sufficient, and in fact, it brings a lot of harm to our current system. It's just not enough. Mr. President, before I finish my speech, may I make a suggestion, a sincere suggestion to the Secretary? If the Secretary is wholeheartedly in support of a reform, may I urge him to take the advice made by the Honourable Member of Kowloon East, Mr. Alan Leung, made yesterday. There's still a chance to make a reform, and there's still a chance that this bill to be passed at this stage. I rest my case for now.